This training is brought to you by the Minnesota Department of Human Services. Ethical Dilemmas, Right to Take Risks versus Right to Be Safe, presented and prepared by Anita Raymond, Program Manager, Volunteers of America, Minnesota and Wisconsin, January 25th, 2017.
We're going to start with some theoretical aspects about the ethics, ethical dilemmas, defining what some of the ethical principles are, and then move into a more practical application of these ethical principles in working with our clients, where, as our title indicates, we're really about trying to sort out today how to interact with clients, how to protect or find that balance between the right to take risks, the right to engage in risky behavior, but also balance that with the right to be safe, the right to protection. We deal with, in our daily lives, we deal with these kinds of conflicts every day. We entered the helping professions, most of us, because we wanted to, at some level, help others. A strong part of helping others is looking at the safety of the people we serve. But this can really conflict with the value or the right to autonomy and self-determination, the person's right to do what makes them happy, even if that puts them in a situation that some of us as providers might see as unsafe. So we have that conflict right away in our daily lives, in our working relationships, because of the vulnerability of the people we serve. If the people weren't vulnerable in some way, they wouldn't need our services. So we're set up right there to try to intervene or find that right balance. When we think about other conflicts, we think about that notion of quantity of life versus quality of life. This is something for anybody who's dealt with the hospice movement. You're very familiar with that conflict, with that. It's actually not even so much of a conflict in the hospice movement. They've got that figured out. They've got that figured out in end-of-life planning or in severe or chronic or terminal conditions. Often the focus isn't on how can we maximize the number of days one has left, but rather how do we find that comfort and that quality. So that's kind of easy in some of the realms of the medical world we work in, but in our day-to-day life, let's think about a client who is overweight and everyone around them thinks that they should be on some sort of a restricted diet, or a diabetic who doesn't want to be on that restricted diet, or a person who doesn't like to take the medications that are good for them, that help keep them safe, but maybe diminish their happiness in some way because of the feelings or the side effects that come from those medications or from that intervention, that restriction of some of their favorite foods. So again, we're keeping them healthy and safe for a long time, but they're miserable. How do we navigate through that? How about provider liability? In the work I do, I very often get requests to help someone obtain a guardianship for an individual because physicians or surgeons are afraid to proceed with a procedure, with a biopsy, with a surgery, because they're concerned that individual does not have full capacity to consent to that procedure. And so that notion of, let's go get them a guardian because I'm afraid I might get sued. And similarly, outside of the medical field, in the social services field, how often is a licensed facility or a group home or an agency fearing what it's going to look like during a state audit if a client or if a person that's being served isn't completely safe? So that provider liability versus the rights of the individual. The notion of the good of the individual versus the good of the group. We each need to worry about our individual, the person we're serving. And I'm going to just stop right there and say, forgive me, I will slip in the word client sometimes. And I know that's not the person-centered language we want to work towards, but it's the language that is still used in my the private sector in the world I work. So I'm working on it. We're all working on it. So if I slip in patient or client or resident, you'll give me that grace, and we all know that we're wanting to work towards more person-centered language. But at any rate, the person we're serving, let's say they live in a community setting and they like a certain kind of music, and they like a certain kind of music very loud, but the other people that live there don't enjoy that. So that notion of what's best for this one individual person versus all the other people that are being served by that provider. How about the loud, boisterous family members who are visiting the individual? It's really good for that person, I think, especially in a hospital setting or another medical setting where an individual needs their rest, they need their support, but what really makes them happy, and therefore what helps healing, is to have their loved ones around. but then the roommate is sitting right across the room and is very bothered, or the other people down the hall are very, very bothered by that boisterous family being there. So that good of the individual one person we're serving versus the needs of the many. So these are some of the, let me back up here. When we look at that's okay, Diane, thank you for your jumping with me, and I'm jumping around a little bit. I want to go through a couple more of the personal before we get into defining actual ethical conflicts. The workers prefer personal versus professional opinions. I struggle with that, and maybe you do too. Let's say I'm working with an individual who either doesn't have the capacity or doesn't have the willingness to sign a release of information so I can talk to their family. So professionally, I can't do anything further with that. Personally, I know in my heart that if I can work with that family and bring them in and keep them engaged and maybe re-engage them with the person I'm serving, we can have so much better outcomes. So that conflict between my personal and my professional opinions. And that goes closely with the next point of the law and policy versus doing what's right. Or how about the example, I think, of my colleagues who would provide social work for people in public high-rise settings. And the person we're serving invites lots and lots of their family members in who end up staying, and they're not on the lease and they're there. That is a violation of the law, of the policy. What do I do with that knowledge when I'm also recognizing that my client has never been happier or healthier since that family has been around? So that conflict, again, between policy and what's right or what I feel might be best for my client. Truth-telling versus avoiding conflict. Truth-telling is such a high value. That's something we can obviously say is the best thing we should always do. But what do we do when sharing the truth? What about sharing something that the person we're serving did with a family member who's a decision maker? We know we should probably share that with them in the realm of transparency. But that because it's and that there's a risky situation going on with the individual, but as soon as we share it with the family member, we know that they're going to come down with harder restrictions. They're going to try to request further restrictions out of a very well-intended desire to eliminate any risk for the person. And we're bringing in a lot more conflict for the individual because now their family's mad at them. You did this again. We told you 4 times not to do that. We keep talking with you about the need to keep your space clean so we don't have eviction problems. So we're avoiding conflict if we don't share all the truth with those outside family members of the people we're serving, as way of example. The difference between our own values and other professionals we work with. As a social worker, in all these years I've been doing this work, I've recognized that I might have a higher tolerance for risk or risky behaviors for the people I serve than maybe my nurse colleagues do, or the physicians who are also serving that individual. So we run into conflicts that way. And then what brings us here today, the sort of way we've always done it versus our new focus and our new language on person-centeredness. Now, for a lot of us, that isn't anything new. We've been doing that all along. We just haven't necessarily used that terminology. But for others of us, this is really a big struggle. We're really finding ourselves not sure what to do when our whole focus of our careers for so long has been about protecting the individual, eliminating risk. And now we're being presented with mandates, again, rightly so, that we need to look at things in a little more person-centered way, in a way that might, in our opinion as a concerned worker, put our clients at real risk. So that struggle we have there. So these are some of the, what I view as sort of the day-to-day ethical conflicts, and I think we could spend much more time identifying significantly more than that. But what I want to turn to is looking at actually defining a little bit some of the actual ethical principles. This slide is really the list of what most biomedical ethicists would describe as the common ethical principles that come into play with the work we do. So, of course, autonomy is what we think of as the primo, the number one. This is at the heart of person-centered planning and thinking, is autonomy, self-determination, an individual's right to make their own decisions. And then we pair that with beneficence, where we as professionals and providers act to carry out our daily lives, to act to promote good. Honesty and veracity, we don't deceive others, we carry ourselves in transparent ways. Non-maleficence, the twin sibling to beneficence. We want to do no harm. and then the promote greatest good for the greatest number of people. So you can see with those professional daily ethical dilemmas I was describing earlier fit nicely in with these. The good of the individual I talked about, the autonomy versus the good of the group, the utility, truth-telling, honesty and veracity versus avoiding conflict, do no harm, non-maleficence. So these are the common ethical principles. I just want to name them because as we talk about going forward in working with clients and working with people and trying to sort through these dilemmas, so often I find when we're really, really struggling with a situation that just feels like we're just stuck and we're just can't move forward, really what's at the heart of it is two conflicting ethical principles. So I think it's just helpful for the dialogue to have names for those conflicts. Why all the focus on person-centered, on autonomy, besides we have to, besides laws and policies that say we have to? But we're ingrained. Those of us who are from this Western-based, this majority society, are the very origins of our country, the Constitution, our Bill of Rights, our cultural values for many of us, all focus on the blessings of liberty. Where the government really can't deprive us of our liberty and without significant due process protections. And again, just our value. We can't turn on the news without hearing things like, get the government out of our lives. We're about pulling ourselves up by the bootstraps. We're independence, freedom. These are strong, strong cultural values for many of us. Not all of us who are maybe from different populations or from newer immigrants to our country. But for many of us, this is just the very foundation we've grown up with, we've lived with, autonomy, the right to exercise self-determination. In fact, in our professions, our social work value, what I'm guided by, the National Association of Social Workers Code of Ethics, my licensing board, the Board of Social Work, require a focus on self-determination. Medical professions, patient rights, Patient Self-Determination Act, the organization I belong to for professional care managers, Aging Life Care Association, all focus on the need to protect and promote clients' or persons' rights to self-determination and autonomy. And then, of course, we have further developments in that direction with the Olmstead decision and our person-centered services. So this is certainly a critical piece in the work we all do, in the culture where we've been raised. But then again, I come back to what about the vulnerabilities of the people we serve? We serve people who are non-compliant. We label them non-compliant. They don't want to agree with recommendations of professionals. Very often a common one in the older adult population is leaving a facility, whether it's a hospital or a transitional care unit or a long-term care facility, leaving against medical advice. We worry about fall risks, again, especially in the older population. For all of the people we serve when they choose to engage in risky relationships. They are victimized because of their choices or because of their vulnerabilities. They are victimized. They live in neighborhoods that aren't safe. And we recognize it. If we're concerned about going to the neighborhood to do a home visit, they live in that neighborhood or a particular household where they're at risk, either just the structure of the household or the other people living there. Again, refusing or only reluctantly accepting care. And then add on top of all of these risk factors, then on top of that, add in the cognitive deficit or psychiatric deficits or intellectual or developmental disabilities, which typically, and certainly in our particular situations that we're most worried about, where it really robs the ability of the individual we're working with to be able to make informed decisions, to be able to protect themselves. They have impaired judgment. So we have this professional need and duty to protect them from harm. Our jobs are about ensuring safety, and again, up until recently, eliminating risk. So again, those vulnerabilities. So we know the self-determination and the autonomy value, but as workers whose role it is to provide services and address safety concerns, we get this feeling of I've got to solve this problem, I've got to reduce, I've got to eliminate this risk. I can't cure the cognitive deficit or the intellectual disability perhaps, but boy, I'm sure going to work to cure that dangerous situation. So these are the vulnerabilities we struggle with, and yet now we add in Olmstead decision and the person-centered planning, and so now we have to provide our services in person-centered ways. And again, as I mentioned earlier, for some of us that really poses a conflict. What do I do when the person I'm serving wants to exercise their right to do things that are really risky? And how am I going to deal with that? How am I going to ensure their safety? What kind of liability might I have for the people I'm working with? And so that's why when we go back to our list of the common ethical principles, now you see I've added another term that ethicists will argue that's paternalism. That's not an ethical principle. In fact, that's a very bad tool. I've been confronted with that when I've been on panels talking about ethical principles. And so I've had to sort of back off and say, okay, paternalism isn't an ethical principle that we think of the way the other principles we've talked about are, but to the degree that we have to work with persons with vulnerabilities and certainly people who in some cases can't protect at all, that is our very job for some of us. Some of us in adult protection, some of us in the role I play, we sometimes have to take that paternalistic view of that parental role in terms of protecting those with vulnerabilities. But that said, we have to recognize that clients have the right to be safe. Okay, so we want to do person-centered and allow people to make choices, but we also want to look at vulnerable citizens' right to protection from harm. What do we do when sometimes our efforts or the efforts of the caregivers we're working with turn the situation to where safety becomes the only goal, because we have to protect people from exploitation, from self-harm, from the personal dignity being robbed by the diseases. So again, conflict, autonomy and protection, autonomy and right to take risks versus that struggle to protect them from harm. Some of us get completely wrapped up in that, and we're going to, again, protect our personal dignity from being robbed by an incapacitating illness. But what about the dignity of risk? What about the right to pick out their own groceries, pick out their own clothing that might not match, that might not be completely weather appropriate? What about, as my colleague Sean Burke says, what about the right to eat Twinkies for breakfast if we want to? Protecting people, protecting the vulnerable people, but what about the dignity of risk? What about the ability to go out on a snowy, slippery day? We might fall and get hurt. You and I take that risk. How often are we saying to the people we serve, you can't do that? So we want to think carefully, though, about the dignity of risk. And this is just a poem, and I wasn't able to, I'm not able to source the author. I can certainly source lots of other trainings and books that utilize this poem or this set of questions or set of challenges to us. What if you never got to make a mistake? How often in working with the people we serve, if they make a mistake or they get involved in a situation where something happens or they get a significantly risky situation, they never get a chance to make that mistake again? What if you were never given a chance to do well at something? What if you never got to make a decision at all? Or the only risky thing you could do is to act out? What if you took the wrong bus and now you're never allowed to take another bus again by yourself because you made a mistake that one time? What if you could, again, in the world I work with, primarily with older adults, this is a big one. What if you could do some of your grocery shopping, but not all of your grocery shopping? And so then you weren't allowed to do any of your grocery shopping. We have all these great services. We'll do the shopping for you. No risk. You don't have to go out in the cold. You don't have to risk falling down with your groceries because it's too risky for you to do that. So now we've, in our well-intended attempt to protect our person and make things easy, now we've taken away, again, that ability to make a choice about a significantly important piece of their daily living. What if you grew old and never knew adulthood? What if you never got the chance? I think this is just a really helpful reminder. I have this hanging outside of near my desk because I think it's something important to go back to and reflect on. when we're in a situation of trying to decide what to do when we're dealing with that situation. Right to protection, right to make risky decisions. I really like this quote on the next slide from Robert Persky, who is thought to have coined the term dignity of risk. To deny the right to make choices in an effort to protect the person with disabilities from risk is to diminish their human dignity. That's what this conversation is all about today, is taking away a person's dignity, the right to take risks and have and experience that dignity of risk. But then again, what do we do, again, about that need to protect someone and help them be safe? So this is our dilemma. This is what we're here today to talk about. I have this little, what we used to call in Wisconsin preschool where I grew up, a teeter-totter or more a seesaw or a scale. We want to think about finding, I just threw this image, this little cartoon in to help in a picture format, help us sort out and remember that we've got a careful balancing act. It's our ethical duty to sort out which side at any given moment and with any given client should we be putting our attention or our focus on. That using our role and our power as a worker to advocate and support the person we're serving's right to self-determination, or should we instead intervene with legal tools to protect them, put that emphasis more on the paternalistic side of we need to protect. What do we do? How do we do it? How do we get it right? Well, let's start with, we have some limits to self-determination. We all know this, but I think it bears reminding and just a brief discussion. Of course, a person we serve, when there's a situation of a vulnerable adult being maltreated, most of us listening today would be considered mandated reporters. The person we're serving, that's a limit to their self-determination. They can't tell us, don't tell anyone this happened to me. As a mandated reporter, we have to report things. Similarly, in many of our licensed professions, we have a we have a duty to warn if a person we're serving is threatening others. We have a duty to call 911, to call psychiatric emergency services if a person is threatening suicide. We can overcome that barrier of lack of consent or of refusal of consent for us to talk to other professionals when the person we're serving is a danger to themselves or others, when they're violating others' rights, governmental code and law violations. It sounds a little silly to go through these because it sounds a little obvious, but what I hear out in the world, out in the field, is sometimes providers in this new world of person-centered planning, what I hear from people is they get stuck on the resident wants to smoke pot. What do we do? Person-centered planning. Do we let them? And again, that's a little bit of taking a lighter look at that. And a reminder, though, an important reminder, because people struggle with that. What do we do when the client wants to do something that's against the law? Easy. They can't do things against the law. There's limits to self-determination. In personal and caregiving relationships, this is a big one in the older adult field I work in, where a person is, for example, very common situation, I want to go home, I want to go home, I want to go home from hospital, from long-term care setting, and it's okay, my daughter will take care of me. And this is something I've evolved in over the years I've been doing this work. When I was a young pup first starting out, and it was all about, of course, the person I'm serving wants to go home. There's a family. They should drop everything and take care of that person. And fortunately, I've evolved and got a little wiser over the years and recognizing, you know what? We don't have, the person we're serving doesn't have that right. We can't violate the ability of that caregiver. If they're doing more than they can do, that now they're putting their lives into their health in danger, their ability to meet caregiving obligations for other people in their lives, that's a limit to a person's self-determination. So we have to look at the whole big picture. And then the topic of conversation today, when a person has incapacities, that's probably a time when we have to at least consider limits to self-determination. But I have question marks after the term incapacity because it's not always. It's not an automatic, we view this person or a doctor has said this person is incapacitated. Oh, there we go. Now we're on the side of protecting and paternalism. Not necessarily. So I'll come back to that. I want to just have a few side conversations or a few minutes side here before going forward to talk about capacity and lack of capacity. We want to remember, just because a person is in denial or making poor decisions, not making any decision at all, just because they're doing things that put themselves at risk or changing their mind or exercising a unique lifestyle or belief system or value system, that doesn't automatically make them incapacitated. And again, kind of obvious when I'm listing it that way. But I think in the work we do, when we're in the trenches, the day-to-day, the struggles, the worries, sometimes we start convincing ourselves, or other professionals or providers we're working with try to convince us, clearly this person's incapacitated because they're in denial, because they keep changing their mind. So we want to be very, very mindful that we aren't looking at behaviors simply because of a person's disability and giving them less credibility or less chance to be considered capacitated because they also have a diagnosis and are doing some of these behaviors. We also want to remember that capacity varies. We want to, if we're in a position of trying to determine a person's ability to make an informed decision, we want to get them at their best. We want to conduct interviews or conversations or assessments with them if they're better in the morning, if they're better in the afternoon. Goodness gracious, we shouldn't be trying to assess somebody's capacity when they're incredibly ill, either through a physical or a psychiatric emergency, and they're in a hospital. That's when it happens out of practicality. It's when it needs to happen a lot of times. But frankly, that's a pretty unfair time. I don't know if anybody out there has the flu right now or even a cold, and with cold medications, or just didn't get enough sleep last night with the baby, and you're just not feeling your best. Is this the day you would want somebody to assess your true and complete capacity? And it's the same thing with the people we work with. We want to be really, really careful. We want to also be careful. Capacity is not, or lack of capacity is not a global decision. That's when we used to use the word incompetent, but it's not a global designation. And I want to really push this point hard because I think we as providers, I know in the role I work in, I get that a lot. A physician, a psychologist, a neurologist has done an assessment and determined, I hear it all the time, this person lacks decisional capacity. So therefore, the next step, guardianship or some other action like such as that. I really want to push back. We want to think about what is the particular decision that needs to be made, and is the person capacitated to make that decision? I don't want to say I don't care about test scores or a diagnosis, because those are important pieces and components, but it really comes down to what's the decision at hand, and can the person understand and make an informed decision? So who decides capacity? The person needing the decision. We as case managers sell out our authority and our power very, very often. We defer it to others very often when, frankly, we're in a situation when we're assessing that person across the table or across the desk from us. And if that person understands what they're doing and understands the need for the particular decision and consent to service or whatever that might be, they're capacitated. If they understand that interaction, they're capacitated, and we shouldn't get caught up in, but they have this diagnosis, they have this score, we have to go seek some other form of a legal decision maker. And on that note, I want to be really, really careful. I hear this one a lot too. I'm working with a person, they've got a diagnosis, they've got some behaviors, they've got some demonstrable behaviors that are suggesting that they're incapacitated. Should we go get neuropsych testing? Should we go get a capacity determination? And what I want to challenge people to think about is the benefit and the burden of that determination. Sometimes it's a matter of what would it change when we're working with in a client situation or person situation with their family. What will it really change on a practical matter to have this big label of incapacitated or a particular diagnostic clarity? And more significantly, what opportunities will be lost when we start to view a person we're working with as incapacitated and they don't have a formal legal decision maker or surrogate decision maker, but now we're labeling them incapacitated. Very often what happens for that person is things stop, gates close, walls come down. We can't proceed further with providing service till we stop and go get a legal decision maker appointed, because now this person in front of us is incapacitated. They're the same person they were yesterday, but now they've gone through some testing and got in that label. So we want to be really, really careful when we're doing that, because it has implications, as I said, for access to services in some cases. That's not a correct approach necessarily, but it happens. It also impacts the ability to appoint a surrogate decision maker. When we label someone incapacitated, then suddenly we have barriers to try to work with them to appoint a healthcare agent or an attorney, in fact, under a power of attorney. So we want to be really careful when we're seeking a formal capacity determination from a professional. What will that change positively and negatively in our working with the client? And on that note, when we have an incapacity diagnosis or opinion from a physician, psychiatrist, psychologist, neurologist, we have that. We have opinions about an inability to give informed consent. These are all important components of determining a person's capacity. But again, it should not be focused solely, or it should not be designated solely on the basis of someone's diagnosis, a testing score, or a behavior in and of itself. And by the way, when we get that incapacity label, I want people to remember, for the reasons I talked about in just a moment ago, it is not a legal determination. A physician saying their patient is incapacitated is not a legal determination of incapacity. It is actually a medical opinion of functional capacity. The way a person gets legally, and the term I hear all the time is deemed, the way a person is deemed incapacitated is actually only after a court determination, in a process which involves due process protections, evidentiary standards in place, clear and convincing evidence in the case of guardianship, which indicates that a person, by appointing a guardian, a court is then saying, yep, this person is legally incapacitated. That's the legal deeming incapacitated. A physician saying it is again a medical opinion of functional incapacity. In contrast, one time when a physician's declaration of incapacity is a legal decision, that's in the situation where there's a healthcare directive in place, and that authority of the healthcare agent is triggered when a physician says the person is incapacitated. So that's one time when a physician's determination is a legal designation. An attorney can determine a person's legal capacity in terms of, are they legally capable of doing a will, a trust, a power of attorney. Those are legal designations of capacity. All the rest are medical opinions of functional capacity. Sounds like we're splitting hairs, but it's pretty important in situations that we're going to come to next. After two more slides. Decisional capacity. No, if you could go back to that one. Thank you, Di. Appreciate it. So decisional capacity requirements, these are the choices these are the components that physicians and the legal field have determined, these 4 content areas that are necessary in order for a physician is serving to be considered capable. They have to be able to communicate choice. They have to understand relevant information. They have to be able to appreciate their situation and consequences, and they have to be able to reason about treatment options, pros, cons, risks, benefits of this treatment versus that treatment versus no treatment. Another way of saying that, or the term many of us are a little more familiar with, is informed consent. But again, sounds remarkably like the 4 evidentiary standard areas that I just talked about a minute ago. They can understand the issue, understand available options, risks and benefits of options, and then make a decision based on reasoning of those areas. A decision's not based on delusion, it's not coerced. The thing I want to say again about informed consent is we, as practitioners, we are capable of working with an individual, a person we're serving, a particular decision, go forth with receiving services, move to this group home, move out of that long-term care facility, if they understand these components and can communicate about that. The other really important thing about informed consent is the burden is not on the person we're serving to just magically know all that. We can't get the person there unless we've really dug in and spent the time, that we make sure, whether it's the physician, whether it's the pharmacist, whether it's ourselves as an advocate, as a social worker, social service professional, we really need to delve in and spend the time making sure the person has been given information in language they can understand, repeated language, repeated information in different formats, etc. Really delving in. This takes a lot of time. It's not simply, patient, you have an aggressive form of cancer, there's this treatment and there's this treatment, what do you want to do now, right? That is not, and then a person answering, that is not informed consent. It's really making sure we've done our work and spent the time with the person delving in. Okay, so that's my little lecture on capacity. Now let's come back to where we're at, the original reason we're here today, to try to struggle through the right to take risks versus the right to be safe. How do we do it? Where do we go? So as I've suggested, the starting point in these situations is name it. Let's sit down, let's explore the issues. What are the ethical dilemmas? What are the ethical principles in conflict here? Let's recognize that, and which one should take more weight. How do we know which one takes more weight? Well, as we've talked about, we want to start with the assumption, let me back up, let me retract that. We want to look at the person we're serving and look at the capacity. With everything we now know about capacity and more, we sort out if the person is capable of engaging. That's our burden, to assess if it's appropriate to advocate for that person's right to engage in risky behaviors. And in that case, that's our job. We advocate for their wishes and facilitate supports. And by the way, we can do that in a way that also tries to address risks. We don't simply say, they're capacitated, this is what they want to do, okay, open the doors. We're doing it in such a way that we're advocating for them, and we can certainly weave in risk reduction kinds of activities. But the primary focus, or the weight on our proverbial seesaw, is on advocating for that person's right to self-determine. On the other hand, if we've gone through and done our hard work and determined that this person is questionably capacitated, the vulnerabilities are such, and the lack of capacity is such that the situation warrants instead, we really need to intervene to protect that person. We really need to limit self-determination and pursue protective interventions. But again, in the least restrictive way, in a way that definitely weaves in to the degree what it is the person wants. And really, that's the essence, too, of person-centered planning, is it isn't simply, as some people think when they first come across that term, it isn't simply what the person wants. It's really doing that hard work of what's important to the person and then what's important for the person. So when we're having to put our focus on what's important for the person, for their protection and vulnerability because of those incapacities, still weaving in what's important to them, and can we leverage what's important to them to get to what's important for them. This is just an oversimplified chart that helps us as providers when we're trying to perform our own risk-benefit analysis to determine where to put the weight, where to put the harm. We want to think about how likely is how likely is it that harm will actually occur. So how do we navigate that maze of conflicting rights between safety and autonomy? How and when do we move from autonomy to paternalism? One way to look at that, quite simply, is, again, having an understanding of the client's capacity to enter into that, but that's not it. That's not the final word. Also balancing in what is the risk, what of the likelihood of risk in that outcome. So even a person who's very impaired, we still want to honor and protect and advocate their rights to make decisions when it's low risk. And we need to err more on the protective side when it's a higher risk. Just if that's helpful to you to use. So let's move then from the theoretical to the practical. What do we do? How do we start resolving some of these conflicts? And we're going to go through these bullet points, and they really do start from the first few are really based on that idea of it's right to, in this situation, for this person we're serving, it's right to advocate and support for that person's right to self-determination and autonomy. That seesaw is balanced heavier on the side of working with the person we're serving their rights. Client advocacy. Everything I talk about or individual advocacy, everything we talk about on this slide is, again, another form of supported decision-making, another form of person-centered work. We're really talking about starting with confronting our own risk tolerance, but moving beyond that, working with the person, with the individual, really working to build trust and join them. This is where, too, we're trying to get at, in a trusting relationship with the person we're serving, really getting past the simply what's important for, getting past just the safety issue, and really getting at what does the person want? How are we accommodating for their disabilities? What are their rights? Are we informing them of their rights? And a critical piece of this, too, again, that person-centered, important to, important for, isn't simply this is what the person I'm serving wants, we're going full steam ahead, but also working with that person, let's facilitate some realistic goal setting, or what we call an insight proxy. Doing that advocacy with the person we're serving, but helping them to get to a point of, okay, but if we do this, here are some natural consequences that may land us in a situation you don't want to be in. So that facilitating realistic goal setting is critically important. We're helping the person we're serving by identifying and linking them to formal and informal resources. We're also using our power and our authority in our need to advocate for the person's needs to really, in some cases, confront other professionals. Remember, we talked about earlier, some professionals or some individuals within the same profession may have a much lower tolerance for risk of what they're comfortable, or our supervisors might have a lower or higher tolerance for risk of what they're comfortable in our relationship with that individual, that advocacy we need to do. So we really may need to confront other professionals as we're proceeding. Supported decision-making, I just want to throw this in. This is a whole nother training. This is a whole nother few hours at minimum of work on that. And there's more videos coming out through DHS. And there's a summit coming up next week, sponsored by Wings, which is almost the entire day is focused on supported decision-making. So I just want to introduce the topic for those who haven't really heard it before, and just in a refresher for people who have. Supported decision-making is an emerging model as a term in and of itself. Again, when we start delving into supported decision-making, and I've got some resources at the end of my slides if you want to do a little self-study on that, when we delve deeper, we recognize, this sounds a whole lot like person-centered thinking. This sounds a whole lot like what a lot of us have been doing already all along with the people we're serving. What we're thinking about with supported decision-making, it's both a tool and a philosophy. As a philosophy, it's something we want to recognize that it is a way to empower an individual to build a team that individual can rely on and trust. And that can be a team including professionals such as ourselves and other caregivers. And it can include people who are important and identified by that person in their life that they can turn to when decisions need to be made. The same way we do every day. We without disabilities don't make decisions in a vacuum. If I'm confronted with a complex medical diagnosis, if I'm confronted with, I don't even know if cars have head gaskets anymore, but if I'm confronted with your vehicle's blown a head gasket, what are you going to do? Fix it or get a new car? I don't have that capacity. I don't have that information just right here in my head to make that by myself. Of course not. I turn to my friend who's the nurse and talk to her about what she might do in her situation. I turn to my husband or to another friend about what might you do with this situation with your car. We all do that. We all turn to our team of supporters to make decisions. Sometimes with people who have disabilities, we sort of forget about that. We sort of forget that people can, in those situations too, maybe with our help, maybe on their own, can build a team of supporters. So we want to think carefully about the role supported decision-making can play in both addressing vulnerabilities as we advocate for the person we're serving for their right to engage in decisions that maybe not everybody agrees with. Negotiated consent is a little bit like what ethics committees do in healthcare situations. The individual may not be able to participate, or they may, but only minimally because of their deficits or incapacities. But we still are able to come together with interested parties, professional caregivers, families who maybe don't have decision-making authority, but they're part of a conversation, and we go through what needs to be done, what's the decision, what are the risks, what are the benefits, what are the outcomes, and we get to a decision without legal authority, without, again, sometimes without the patient being, the individual being involved, or sometimes if they're involved, but they don't truly have capacity to make an informed decision. So it's about getting to a decision, getting to a plan in a negotiated consent fashion, if I can oversimplify. Again, sounds a bit like supported decision making in some situations too. So that's a tool we might use. But what happens when we just can't do that? When we do have an individual for whom the capacities are so significant that the vulnerabilities are so significant, we just can't overcome that. And then we need to tip that seesaw to the other side of, we really need to use our role to intervene, to seek protection, to protect the client's right to safety. So let's talk about some of the tools that are available that way. We've got a toolkit. We've got a much more expansive toolkit than some people think. Sometimes we think, I've got this person, they're incapacitated. We've got through that. We've tried everything to work with them. They're just resistant. They're difficult. They're completely incapable of communicating. Let's go. We better get them a guardian. And I really wanted to lay out that we have significant tools in our toolkit to turn to before we even get to looking at the guardianship or other court intervention. So what I call it takes a village. We want to start with even a person who is incapacitated or questionable capacity. We still may not have to go down that legal road if we can bring in family or whoever that support team is, family, friends, whoever is in their support team. I added on the slide authority figures. Sometimes they're religious leader. Sometimes they're physicians. Sometimes somebody that is their supervisor in a work setting. The influence of people who are important to that person we're serving. If we as professionals can step in and give them permission and coaching of how they can step in and take a more active or a more effective role in bumping up, moving from, again, I'll use the example of the older adult field, moving from that adult child, emphasis on child, to more of a parenting role. It's now time to step in as a caregiver and try to influence, work with that person, use their influence to seek cooperation with the individual. I'm just going to keep going because we do have a lot to talk about today. I could talk a lot more about the role of family, that really we could leverage them a lot more than we sometimes do. Because we sometimes get caught up in, they don't have legal authority, so we got to go get legal authority. I think there's just so much more we can do to use the influence of them with the individual we're working with. A care manager, whether it's a private pay care manager or a county case manager, we have a lot more power than we often think. Again, with that client advocacy, working with the client, but also, working with the individual, but also where we can't garner their involvement or their cooperation. We actually also have more authority. This is going to be controversial, and maybe I'm going to watch around the room and see if people's hackles go up. But we kind of have the authority in terms of consenting to payment situations. When we're a waiver case manager and we're approving services or a setting for a situation, if it's not a safe setting, maybe we shouldn't be working towards approving those, right? Or putting together those plans if the person isn't going to be safe in that place of their choice. So using our authority, our gatekeeper, our role as a gatekeeper to resources can sometimes make a difference to getting to that safety position when necessary because of the vulnerabilities and incapacity. Using institutional policy and ethics committees, I've talked about that when the people we're working with are dealing with a medical decision, but they don't have a legal decision maker. Often institutional policy or use of their formal ethics committees can get to a decision without having to go down a legal decision-making route. Again, each of these we could talk about a lot more, and I apologize that we're running through them pretty quickly. Don't forget the role of the attorney. If the person already has an attorney, or their family, if we're working with a younger adult, their family attorney, much to our surprise, oftentimes people have done some advanced planning already for such a day as when they're incapacitated and can't make their own decisions and can't consent to their own cares. Sometimes they've done some planning years ago, and it gets put on a shelf or in a file in an attorney's office, and we never know that they've already done some important planning, such as appointing an agent or an attorney, in fact, under a healthcare directive or a power of attorney. So turning to the attorney to determine if things have been done, or sometimes the attorney can be helpful in leveraging cooperation with the individual where we as social service providers might not have been able to. Another tool I think that's probably underused is banking tools. When that person is just not able to use their money safely to pay for services, to ensure their needs are met before they're buying their Twinkies for breakfast, auto pay for bills, direct deposit of incomes, authorized signers on checks, and then also that goes closely with representative payee, but I didn't put it on this slide because I was trying to get at the village support, trying to leverage towards voluntary cooperation. So banking tools can go a long way towards getting the person what they need. I'll come back to managing money in just a little bit. And then as we start to apply more pressure, we move again further and further away from trying to work with the client to try to protect them sort of over their wishes, because we have to, because of capacity and vulnerability issues. So when we move up the scale of applying more pressure or seeking influence or natural consequences as a pathway to resolution, city inspectors. Sometimes a city inspector coming in and saying that there needs to be work orders issued by city inspector in order for this house to not be condemned, so that person can keep living here. So that person who we've been struggling with has been saying, get out of my face, everything's fine, leave me alone. Sometimes upping the ante with this, your house will be condemned if we don't find a way to deal with this. We can garner more cooperation that way. Similarly, a notice to evict or discontinue services can sometimes at that point help the person understand, oh, you're serious. We really need to make some changes. And sometimes the role of adult protection, when it meets criteria for reporting and when it meets criteria for adult protection, getting involved, just their very involvement, working intensively with the individual and their family as part of developing an appropriate protective plan can go a long way towards getting some cooperation where maybe we didn't have it before. Then as we move in further into legal surrogate decision makers, we can't get around it. We can't do any of these informal things we've talked about despite our best efforts and our most creative approaches, and we need to turn to legal decision makers. So I'm going to go into some voluntary tools and then some involuntary tools. All right, let's go to the next slide, Di. Thank you so much. A couple things I want to point out about a healthcare directive. First of all, if a person already has a healthcare directive, I hear very, very often somebody has a healthcare directive, maybe even they also have a power of attorney, but that same person is kind of resistive to intervention. Leave me alone. I don't want any help. And so often professionals such as ourselves direct those family members who have that authority, direct them, well, now you better go to court and seek a guardian or conservator. And what we try to do in our office, and hopefully after today all of you will do too, is back that conversation up. If there's already a healthcare directive in place where the principal appointed, the person we're working with, appointed an agent to step in and serve, as I alluded to earlier, what we need in that case is not throw it out and go get guardianship. What we need in that case is the physician to say, which is the default statutory requirement to enact, get that going, get that agent's authority in place, is for the attending physician to say this person is incapacitated. Now we have legal authority to make healthcare decisions, including the decision to decide where the person resides to receive medical care. So the place of abode falls under that healthcare decision. That's an important thing I want people to remember when there's a healthcare directive already in place. The other thing that's really important when there's not a healthcare directive in place already, This is the part I'm tying this back to when I talked earlier about what happens when we get that designation of incapacity on that person's problem list or diagnostic list. Now they're incapacitated. Now, many will try to say this person is no longer eligible to enter into a healthcare directive. And that's not necessarily true. It may be true, but not necessarily. The thing people need to recognize about healthcare directives, and similarly when we get to power of attorney, same thing. The ability to make a medical decision, to do the medical instructions portion of a healthcare directive, and by the way, healthcare directives are for anybody over 18, not just for older adults or end of life. But what a healthcare directive can do, or the statute allows for the person to name an agent. That is a much lower bar of legal capacity, legal ability to understand what's going on in their situation, to name an agent, than it is to make complex medical decisions. And of course, those of us who work with healthcare directives know those are the two components of a healthcare directive, and it's an either and or situation. So they may be too impaired to say, if I had this condition, I would want this kind of treatment. These are my medical values. That may be beyond that person's intellectual grasp. But I bet they're able to say consistently, reliably, I want my daughter, I want my brother, I want my uncle to make my medical decisions for me. That may well be sufficient capacity to enter into a healthcare directive. But too often the door is closed when someone has sent them off to get capacity testing and they come back with a diagnosis of incapacity. So that ties back to that point. Similarly, power of attorney, I'm not going to spend a ton of time on the money piece because I suspect a lot of us are dealing more with difficulties with decision making with regard to our personal affairs. But it is important to recognize whether it's power of attorney or representative payee or trustee or conservator, when we control the purse strings, we can control access to services significantly. A person may say, I don't want that level of care. I don't want people coming into my house. I don't want that arms worker. I don't want to move to that residential care setting. But again, when it's significant issues of lack of capacity and it's significant issues of vulnerability, and we control where the money goes, we control which rent is going to get paid, which leases are going to get signed, we can go a long way towards connecting the person with those necessary safety situations by controlling the purse string. And so the point I want to make about power of attorney is similar to healthcare directive conversation. A person may well be capable, they can have a basic understanding, need to have a basic understanding of their financial situation, a basic understanding of what it means to sign that contract, because it is a contract, but to appoint someone to serve as their attorney, in fact, is the name of the person managing the money with or for them. So again, we sometimes close that door for a person to be able to enter into those kind of planning tools if we go ahead and get them labeled incapacitated. But the point I want to make, and I'm over making, is that they certainly may still be able to appoint a financial decision maker to protect and manage their money. Representative payee is another critical one that I think a lot of people forget about and have misunderstandings about. But representative payee actually can be involuntary. In fact, is most often involuntary. I hear that a lot from case managers. I thought about rep payee, but the person I'm serving doesn't want it and doesn't agree with it, refuses. And so they think that's the end of the line. But in contrary, Social Security Administration or the Veterans Administration, Railroad Retirement Board, whatever that governmental benefit is, will appoint an agent, a payee, on an involuntary basis. There's a procedure, there's a medical opinion that the person can't manage their benefit that needs to happen. The person has the right to appeal, but it is a really, really good tool. In fact, just sometimes the perfect tool when the only income asset is the governmental benefit. As I said earlier, don't want to underestimate the power of the purse strings. When none of those are possible, we really have tried really, really hard. We've intervened, we've advocated, we've really tried to get creative and find less restrictive ways, but we just can't overcome that burden, that barrier, because of the person's resistance, because of the person's incapacity, because of the heightened level of vulnerabilities. Then it may be, in fact, time to intervene with court tools. Guardianship, conservatorship, commitment, this whole nother training, whole nother hours or days we could spend on that. So we're not going to get into the weeds on that. But just a couple brief summary statements for you. When do we intervene with court tools? Quite simply, when the person is a danger to themselves in terms of whether it's threats or self-neglect. or others, danger to others in the realm of commitment, or they lack cognitive or intellectual capacity or psychiatric capacity, and their needs are unmet. We can't get those needs met in any other way with any of the tools that we've talked about already today. Or there's a personal or financial decision that needs to be made. There's conflict about a decision, so we can't get there. We can't overcome the conflict. Or my least favorite reason ever for going to court and asking the court to remove a person's constitutional rights, it's required by policy. I would like us all to work really hard to avoid situations where we're getting a guardian because some policy says we have to in that situation. But that's also the reality we work in some situations. So when do we intervene with court tools? When that person is incapacitated and completely unable to receive services in any other way except this intrusive intervention. So very briefly, the legal criteria for guardianship. This is an oversimplified list right from the statute. We have to be able to prove with clear and convincing evidence that the individual is in fact incapacitated, that they have some kind of psychiatric, cognitive, or intellectual or developmental disability such that it robs them of their ability to make or communicate responsible personal decisions, even with assistance, such as technological assistance. That's not enough. We also have to show behavioral deficits. They currently aren't getting their needs met. So they can be very, very impaired, but they've got a strong support system. They're in a setting, whether it's their own home or a residential setting where all their needs are met. There's no unmet need. We don't meet that second criteria. Yes, if they were set out on their own, they would demonstrate with their behaviors that they can't meet their own needs for food, clothing, shelter, medical care, safety, supervision. But that's not the situation. They're in that setting. So incapacity, behavioral deficits, and the critical one, for my purposes, that there truly are no less restrictive ways that we can meet that person's need. The only way we can meet their need or get a decision is by going to court and seeking guardianship. The other piece that is not statutory, but that I push really hard in my one-on-one conversations with people, is we also want to sort out, will that guardianship actually even make a difference? Sometimes the situation is we turn to guardianship because of significant behaviors, and we think, well, I don't know what else to do. I feel like I've tried everything else. This must be that last resort situation. Let's get a guardian. But what I really challenge people to think about first is let's wave our magic wand. Let's pretend we have a guardian right here, right now. What's going to be different? Is that person going to suddenly start behaving or agreeing or consenting because there's a guardian? Absolutely not. In that case, let's not waste resources, and let's also not go down that road of taking away a person's constitutional right to self-determination by seeking a guardian. Again, don't want to spend a lot of time on conservatorship, but I just want you to have the general idea with the statutory requirements to be able to go down the road of conservatorship. There has to be money to manage. So for a lot of the folks, especially those of us working in the waivered world, if medical assistance, if governmental benefits are their only income, there's nothing to manage. We don't even need conservatorship at all because Payee is a less restrictive alternative. But when there are assets, when there are income, pensions, income beyond governmental benefits, and we may need to, again, if we meet criteria, they've got an inability to manage it. It either is going to be wasted or dissipated without intervention of a conservator, or we have to access that money in order to pay for needed care, support, and services. And again, no less restrictive alternatives. That's the criteria for conservatorship. Commitment. This is incredibly oversimplified, so don't write in. I know this is an oversimplified slide. I just wanted to remind that that's another tool for interventions in some situations when the person meets criteria for being mentally ill, developmentally disabled, chemically dependent, and can prove that they're a danger to themselves, including self-neglect, or others. And again, no less restrictive alternatives. That's a whole nother day's topic, so we're not going to spend a whole lot of time there. And then in summary, when do we avoid court intervention? Whenever we can. Whenever we can get, when that person, of course, is capacitated, they have the right to make even really poor decisions. Whenever we can meet needs in any other way. If we haven't tried hard enough, we haven't tried alternatives, it's not time to go look at court yet. When it's not going to be effective, when there's not a current need, we don't do guardianship proactively. I know for those of you who are social workers like me, we're trained, it was ingrained of us in social work school, proactive. Guardianship's not a proactive tool. because again, I've said it enough times, it's taken away a person's rights to self-determination. So we don't want to do that simply because they might need it down the road. We don't use guardianship as a proactive tool. And we don't seek court intervention if we can't even meet the need. Let's not put people through the trauma of a court process if we ultimately aren't going to succeed in that. The next slides are, I'm not going to read those to you. I do hope you take some time to read them and reference them, both the Alzheimer's Association and then also the ARC and the AAIDD is the, I'm going to get it wrong anyway, but anyway, the Association for Intellectual and Developmental, I think it's American Association for Intellectual and Developmental Disabilities, recently came out with a joint position statement about autonomy and decision-making and guardianship. And I just put this in here for your reference as well. And these are sourced on the last couple slides. So we're just kind of flipping through these quickly because you have them, you can spend the time with them. And we have about 10 minutes left for some question and answers. Resources for you there at Magic, at the Volunteers of America sites, state court websites, the program I'm with, which is a brand new program, which is funded by the Administration for Community Living in partnership with LSS Minnesota, a couple divisions of DHS, and the Minnesota Elder Justice Center. We're able to keep doing the kind of work I've been alluding to today, phone-based consultation, in some cases assessments, supporting surrogate decision makers, education training. There's our contact information. I'll stop with the commercial. And thank you, and we can take questions and answers.